going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm Rick.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Happy Friday. We made it. It's the end of the week. Happy Friday. All right. You guys want to watch some court? I want to watch some court. First and foremost, giant shout out to Team Skeptic. It was a lot of fun last night. I love it when he comes on stream. We have fun. Um, because he was on stream last night, the video I had ready for last night, I pushed it to tonight. So these cases happened yesterday. You may have seen at least the first one. The first one's it bounced around everywhere, but I've been covering this guy, so I wanted to go ahead and play it for those of you that have not seen it. I did not link the first two parts into the description. I probably should have. If I remember, I'll go back and do that after the video is over. All right. So we're going to start out with Judge Stevens, and yeah, I think that's all I have to say. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Are you here in
Yes,
this
you
one? We now call cause number 23.
Oh, real quick. When Judge Stevens kind of squeezed this hearing in a jury trial. So he's having a jury trial right now. Well, while this was going on, and he always covers the camera when he's in the middle of a jury trial. He covers that camera. So that's why that's up there. He does fix it about halfway through, but yeah, you're going to stare at that for probably the first 10 minutes of this hearing.
CR 1439, the state of Texas versus John Walter Bordash Jr. The defendant is present with Mr. West, John West, his attorney, and the state's attorney. We are picking up a matter as soon as we have gotten the information concerning the matter of competency concerning the defendant. A motion suggesting incompetency and request for examination was filed on in October of 2024 by the defense, and we had some matters taken up in the meantime concerning the defendant's placement on bond. This indictment of the defendant was handed up by the grand jury on September 20th of 2023 and has been pending. And we've had some matters over the course of that time concerning defendant's bond and whether his bond should continue based upon circumstances that were brought to the court's attention. Then the defendant was placed on bond, and then later his bond was revoked by this court upon a hearing determining that the bond conditions were not being met properly by the defendant. A motion suggesting incompetency and request for examination was filed again in October of 2024. The court ordered Dr. Ed Grappon, licensed psychiatrist, to conduct an analysis and evaluation of the defendant. That was done. We have received Dr. Grappon's report dated February 3rd of 2024, and the court.
Yeah, that's actually a great point, Derval. I knew he was a doctor, and I want to apologize for whoever sent me the news articles because I meant to look. Somebody sent me news articles, like local news articles of this guy, and just how wild he is. And I found out in the article that he was a doctor. That's the first time that they have brought that up in court. But this guy actually is a doctor.
Has given copies of this to the state and to the defense. I am, for this particular hearing, calling this and marking it Court's Exhibit Number 1 on today's date, February 6, 2025, in this cause number. It will be made a part of the record for proper purposes on any issues involving this particular matter. Any objection by the parties?
No objection.
State and defense?
No objection,
No
Your Honor.
objection. It is made a part of the record, and it will be sealed. And only information will only be disclosed to the necessary parties, that would be people who are treating the defendant, or for the parties as necessary for legal matters that may arise in this case. So, in summary, upon evaluation, Dr. Grappan's report includes information about Dr. Ed Grappan, where Dr. Grappan is a licensed psychiatrist. This court is well informed of. I believe I first met Dr. Grappan when he was brought into the James Byrd murder cases that this judge was part of the prosecution of in
12 months always gets a pause. Rich, thank you so much. That is awesome. Congratulations on the year. And yeah, OG right there. Thank you so much, Rich. While I'm paused, 13. Welcome to the family. Thanks for becoming a new member. I do appreciate it. Thank you both.
1998, and Dr. Grappan analyzed defendants and testified during that trial for issues that came about during the sentencing of the defendants. So the court has known him since 1998 and known Dr. Grappan to be a highly qualified man and has his medical doctorate in psychiatry, and has evaluated countless individuals in his civil practice and in criminal cases here in these courts in Jefferson County for decades, and his reputation is pristine on his abilities and his competency in doing his job. He has prepared a 5-page report after evaluating Dr. Bordash at the request of this court, after this court found good cause to have Dr. Bordash evaluated. And it has been made a part of this record as Court's Exhibit 1 for this hearing and any other purposes that are relevant to the defendant's competency. And within the report, the doctor details his interaction and his speaking with the defendant, and is quite apparent in his words that Dr. Bordash demonstrates significant paranoia, particularly in regard to the legal system. His judgment is impaired. His insight is almost nil. He is diagnosed by Dr. Grappan with delusional disorder, non-bizarre. As to competency, the defendant is not competent at this time to proceed to a resolution of his legal issues. He does not possess in his current state the ability to communicate with his attorney with a reasonable degree of rational understanding in the preparation of any defense. The defendant is mentally ill by definition. He would require involuntary psychiatric treatment intervention for restoration of competency. He has no insight into his condition and adamantly believes he is being victim.
That's actually a great question. I don't remember the underlying charges of this case. It has something to do with his neighbors. He lives right next door to them, and he's got some kind of no contact order with them, but they live next door, and he keeps harassing them. So that's what he's in jail for now, for violating a bond condition where he wasn't supposed to have any contact or any kind of harassing activities. And he was like banging on the side of their house with a, I don't remember what he said, a broom or something. I don't know.
By this situation and the legal proceedings surrounding it. It is very unlikely that he will accept that he is operating under a totally false belief system. He states repeatedly he is the victim of electronic harassment perpetrated by his neighbors. And when asked about any of his legal difficulty, according to Dr. Rapon, the defendant gives a very paranoid and/or delusional explanation for the total scenario. All right, then the final determination is that the defendant is mentally ill, is incompetent, and needs a hospital treatment, inpatient treatment at a proper facility of the state, with our hope of him gaining competency to stand trial in this case. Anything the state wants to add to this report?
No, Your Honor.
What about the defense?
I do not, Your Honor. However, my client has reviewed this report and does not agree with the report.
Okay.
And did want to address the court. But I will stand by the report. I'm the one that requested the competency in the first place, so I don't believe it's competent. So I believe the doctor's suggestion is correct, but my client does want to address the court.
Okay. Is that right, Dr. Bordash? You want to make a statement?
Yes,
Raise your right hand. Do you solemnly swear or affirm any statement you make will be the truth, the whole truth, and nothing but the truth, so help you God?
yes.
All right, lower your hand. I think you marked, I gave Mr. West a copy of this. You marked on that document. It's a duplicate. It's a duplicate of a true and accurate copy of what the court received from Dr. Edgar Pond, and I marked that as court's exhibit number 1 that you referred to and make notes. I didn't read your notes, but you can refer to those as necessary if you wish, and that's for you and your attorney to have. Go ahead. What would you like to add, sir?
Oh, well, Dr. Papon says I performed a standard psychiatric interview with the formulation of a formal mental status exam. No, he did not. I was not given the mini mental status exam, MMSE, and the Montreal Cognitive Assessment, also called the MOCA for short. And page 2, I guess he, third sentence from the bottom, it says he denies a history of mental health treatment, but has for a number of years been under the care of local psychiatrists for a diagnosis of narcolepsy, for which he takes Adderall on a daily basis. Actually, I acknowledge a history of mental health treatment for neurocognitive issues, for example, attention, concentration, processing speed, and motivation. And let's see, and has been for a number of years under the care of a local psychiatrist and some in Houston for diagnosis of HIV-associated neurocognitive disorder and narcolepsy, for which I take Adderall on a daily basis. But it also helps with trigeminal neuropathy. The next sentence, he does report that he has had essentially annual neuropsychological evaluations done over the past 10 years because of concerns about cognitive issues. That is true. However, it is because that I've been conscientious of ethics issues pertaining to competency for a long time because of my condition. And I have volunteered to undergo neuropsychological evaluations on an annual basis to confirm that I can continue to work on a part-time basis. For this reason, I've been showing conscientious. I've been very conscientious about the ethical issues of competency. And I have been having Dr. Mario DeLay of Methodist Hospital in Houston in the medical center conduct these evaluations since 2011. Next page. Dr. Grapon says he reported that the date of his next examination was due to be at the end of January 2025. Yes. And a neurology consult was also set up by me for January 20th, 2025 at 3 p.m. with Dr. Mary Bowe.
I honestly don't remember. I don't know why psychology is in my head. That's actually kind of funny to say it that way. I just cracked myself up. Yeah, I don't know why. Psychology is the first thing that comes to the tip of my tongue. But I don't know. Something along those lines, I'm gonna say. Some kind of brain science. Let's just say that. There you go. Psychology, I was right.
VOMD. Let's see. The sixth sentence down. Apparently, this involves some interactions between he and the neighbor, which he seems to have generated by his delusional belief that they are somehow adversely affecting him through electromagnetic waves. Now, my response is, whereas I acknowledge that in the past, patients were at one time considered delusional when they made these kinds of remarks, recent research over the past 10 to 15 years would suggest that there is some scientific validity to these claims. And certainly the World Health Organization has adopted electromagnetic hypersensitivity syndrome as part of the ICD-10 diagnostic code book. The next one is, let's see, where it says affect is generally appropriate, although he has a number of somewhat paranoid ideas in regard.
KFAR, this is the latest one. I think this is the third one that I've covered. This one happened yesterday. So if it's the next one in your order, then yes, it is.
Of the legal system, the reason for he is in current legal difficulty, etc., etc., etc. Actually, no, I have reservations, not paranoid ideas. And the next one is he has a fixed delusional system in regard to what he feels are health-related problems that he is having because he is absolutely convinced that his neighbors are poisoning with microwaves from their home to his residence. No, I'm able to distinguish when symptoms of microwaving are occurring and when they are not, and to discriminate between who is most likely to engage in such deadly conduct. The next one is, he basically told me that he has had some type of device which would read the stream of these electronic impulses, and he could determine that they were coming from the neighbor's residence. It's really kind of well, not specific enough. Actually, on any kind of cell phone device, you can download applications that are written specifically to detect electromagnetic waves and their strength. Actually, you can see on any cell phone that there's a antenna icon with that gauges the strength of the signal that you're receiving. And so that's the same sensor that is being used by these applications. The one I was using is called gauze meter. Gauze is a measure of the strength of a magnetic field. And it can also be measured using units called Teslas or microteslas. In these applications, the one I ended up using more than the other was gauze meter, because I can take constant readings up to 300 second intervals and locate where hotspots were being found in my home. The first one was in the right bracket of my shower. It would sometimes the readings would be as high as 5,000 microteslas or higher. And then on the shower wall that separated the jacuzzi, those readings would go down to maybe 3,800 microteslas. Past that is my master bedroom closet. In line with the shower wall bracket, readings could go down to about 25 microteslas. And then in the garage, about 10 feet from the garage door itself, was still in line with the shower. The readings would go down to about 2,000 microteslas. Now, the progressive decline in strength of magnetic fields would indicate that it's coming from the direction of my neighbors. They have never had a white tint put up in their backyard before, until I started having these experiences, and so they are coming from that direction. I've also determined that at times the whatever device is in that tent is sometimes shifted, and I pick up high readings around between my bedroom window and where I lay my head on my bed. Since then, I have put in a door glass, a pane of door glass from a previous office, because glass is used as an insulator for magnetic fields, electromagnetic fields, and that was enough to reduce the signal strength from about 2,800 microteslas down to about 700. So about a 75% decrease in these strengths. I've also put jugs of water to try to absorb the rest of the microwaving. However, that proved to be a kind of messy, because by morning time, the jugs had expanded because of heating and leaked onto my.
But allow me to interrupt, just please. I think I understand. You are in more detail, but repeating what you had earlier toward the court before in previous hearings on this matter. Let me ask you what you've never articulated to this court clearly is, why would your neighbors do such a thing that you think they're doing to intentionally cause you harm by this surreptitious, microwave attack on your mind?
Okay, not on my mind.
Why?
My person.
Yeah, why would they do that? What do you think the motive would be if this is true?
Well, it could be religious objections to my sexual orientation and the fact that I was in an interracial relationship. I mean, years ago we had.
Okay, you think that might be it?
That might be it, amongst other things. The fact that I suspended fees because Miss Payton showed up at my door making ridiculous claims that I should pay my fees because we needed to replace the street. That street won't be needing to be replaced for another 75 years. So I don't think.
Are you talking about homeowner fees?
Yes.
Do you? Oh.
I don't think we should be taking up,
Well-
paying fees when neither one of us is going to be alive when that street needs to be replaced.
What else do you think? What else?
And the fact that, whenever we had a homeowners association, which I have not been invited to for ever since Mr. Warren and Mr. Yates moved into my home, a gentleman of color with whom I had a relationship for about 25 years, and lost him to a number of factors that were.
Is there any?
Terribly heartbreaking.
Okay. Otherwise,
anyway, we used to have lawn care service that was provided by a black-owned a company. Okay, and they did a good job. That all changed when because Miss Payton and Mr. Payton are very prejudiced individuals.
Okay.
They had a robust gentleman from LaBelle, the name of Kane, provide yard care service until I raised the issue with the fact that he kept raising fuel cost. But when I looked at a graph provided with about the cost of fuel over a 10-year period, it was pretty much now it was erratic, but it was
you've made. I think I understand your point. Is there anything else you want to add?
With regards to Dr. Grapon's report?
Yes, sir.
Okay, yes.
This is the focus of where we are.
Keep going. Let's see. He will admit there is no medical provider who has supported his opinion, and that is the basis of his alleged medical problems. Actually, I would rewrite that as he will admit that there is no medical provider who has validated his hypothesis that is about symptoms that have experienced that are specific to electromagnetic hypersensitivity. Hypersensitive syndrome. I understand the need for independent third-party validation to my claims. Okay. And then the next sentence. Apparently,
I know what he's saying. I've read it on numerous sites. It's in the record. We're taking time up just repeating what's been said. I just want to know what you want to add that's not duplicative of what he has already stated.
I've had a Latino tile worker notice the difference in the.
Yep. Still happening. How's everyone doing? Oh, it is. It's 8:30 already. All right. Looks like it came back really quickly tonight. Let's see. It's probably going to happen again. It never just happens once.
I acknowledge myself that in the past others have been described as delusional, but I possess the research skills to use appropriately designed applications to measure electromagnetic flux in the environment, take repeated measures that are reliable and concentrated in areas of my home, and to determine the direction of the source by the strength of the signals. I don't know if his wife is.
No, David. I don't want to get into it too much, but I'm kind of dealing with a small little health issue that caused me to miss my appointment on Thursday. And I completely looking forward to it all week. When it actually happened, I missed the phone call and I had to reschedule. So it did not happen yesterday like it was supposed to. So we got to move it to next week.
Directly involved. I think it's more Mr. Payton and their yard man. They feed into one.
All right. Yep. Jedi was right. Jedi was right. I jinxed it. Gonna wait a minute, see if it happens again. What's up, Rodney? Good to see you. Thank you for hanging out. Thanks, David. I appreciate it. Hey, what's up, Grandma Gaga? All right. I think you know what? I actually have Terry. Thank you so much for the 5 months. I appreciate it, my friend. That is awesome. Thank you, Terry. All right. It's 8:31. We might be good now. We might be good. Do you guys want me to rewind it a little bit, or are you guys good? I'll wait for the first answer. Hey, what's up, Beverly? Hey, Carrie. Oh, I get it. I get it. It's fine. It's fine. Okay, you're good. All right, let's go.
Is not a right.
Okay, you've expressed that a couple,
Yeah.
sometimes before. What
Okay.
else, sir? We need to conclude this hearing and move forward.
I'm able to, okay. And I would not say so much that they are producing some type of electronic signal that is causing me various symptoms. They're generating these microwaves that
12 months always gets a pause. I'd say that all the time, and I know I sometimes don't pause it instantly. But Robert, thank you so much for the 12 months, 1 year. That is awesome. Thank you so much. You are awesome. OG member right there.
or inducing symptoms separate from symptoms associated with HIV associated neurocognitive disorder. So I'm able to distinguish that there is two issues. And let's see, by a process of reasoning called convergent validity. Okay.
What else?
Also that these
Well, the good news is it hasn't kicked me out tonight. It just keeps catching up pretty quickly. So I wonder if that means they're fixing it, whatever the issue is going on. All right. Well, let's keep going. Let's see if we can let this ride.
electromagnetic flux. Okay. So I do not think my judgment is impaired. However, a person exposed to these inductions can be under a great deal of emotional stress, such that one might be desperate to stop them. I'm not keen on reacting or responding to any aggression that is shown towards me. Instead, I think of ways to arrest them.
Yeah, Lone Wolf. It's happened every night for a week, right at 8:30. It's actually 8:28. At 8:28 is the first. I don't know what to call it, hiccup, and then it generally happens 2 or 3 times between 8:28 and about right now. So we should be good now, but it's 1 week straight. It's happening right at the same time.
So that people just expend their energies for nothing at all. They're not reinforced for them, and I'm not faulted for responding to them. And one of the ways is that I've bought 20 to 40 yards of Faraday fabric, which is fabric infused with copper and nickel particles that reduce the entry or the strength of electromagnetic waves into my home. And they have been exceedingly successful in doing so.
You made that point. Conclude, please. Thank you.
Okay. I would take issue that that I can provide a rationale for my experiences that can be validated independently, and that I do not, I'm not mentally ill in the sense that I have an emotional or affective disorder, but rather I have neurocognitive deficits that are consistent with the dopaminergic reward system in the brain and its purpose. Okay. I am willing to accept voluntary psychiatric admission to Methodist Hospital under the care of Dr. Vo and Dr. DeLay. I do have insight into my condition. In fact, because a PhD teaches MDs, I'm often.
I do not. The way that my internet is set up, I can't directly access my modem. I've tried. I've even called my ISP for to try to just let me get in, but it's owned by my apartment. So my apartment building supplies the internet, so I don't have access to it. I had to, yeah. There's a lot that's going on with the internet here, and it's a long story. But to answer your question, no, I don't have access directly to my modem.
I often educate them about my condition, and I can provide research reports to back up my opinions. So I suppose that's by and large everything I could
Okay.
add.
All right. The court, and what you are telling this court, do you stand by its accuracy, the accuracy of what you have told this court under oath?
Yes.
And is this the same accuracy that you have used in the interactions with this court in the past when you speak to the court or make statements to the court? Is it that same accuracy that you have used in the past?
Yes.
Okay.
Yes.
All right. I'm going to remind you, you remember when I think one of our first meetings, you called me a drunkard. And we all heard that. And that I had a reputation of being a drunkard when I don't drink alcohol. Do you remember that?
Well,
Do you remember that?
yes,
the
I remember
point is
yes,
that
and there was some basis for me saying that.
there was, God bless
Yes.
you. Well,
Yes.
were you mistaking me for somebody else?
No.
Oh, okay. Well, okay. Everybody,
You
this
were-
whole town,
you were identified as attending a
this
meal?
court does not drink alcohol.
Okay.
And, that's
Okay.
I'm a soft
Well,
drinker, and
I
that's
was
the way I
informed by a
am.
gentleman that whom I
There's been a few defendants that have called him that. I've seen at least two others. Yeah, and I mean, and I'll be honest. I've said this before. I thought that when I first saw him, because whenever he would take a drink, he'd be shaking really bad, and that's the first thing that went through my head. I don't have the balls to say that to a judge, though. I'd be like, yeah, it's probably not it, but it is the first thing you think of. But I don't know why a defendant would think it's okay to say that to him.
had no reason to question his validity
All right.
since he worked as a waiter there at my restaurant.
All right. This court doesn't purchase alcohol from businesses.
And there was also an alternative
restaurants. I don't.
hypothesis.
But that's
Because of
that's
your
neither-
tremors.
that's the first time I've ever heard that one. But in this job, this court is not surprised of what can be said, but it's what is supported.
Well, have you taken medication before? Are you
Sir?
taking medication now for your tremors?
Oh, my familial tremors,
Yes.
which you see, that's another thing.
Are you
These
taking
are this
amantadine?
is, you have misdiagnosed this as well. Yes, everybody knows that this court has what's called familial tremors. I got it from my mother. My mother had it, and so it was passed on.
I
But
understand.
I also have am an artist. I'm able to control those, and no, I don't even take medicine for it. I've only had it my whole life, and it has not affected anything to do with with my ability to think, function, and that's, you and I are completely different, sir. This is apples and oranges, what we're talking about. And this court, there's been never been a question about this court's competency, nor a question of this court's ability to conduct myself physically. And I actually still run in the 10K whenever I can. I think it's pretty good. And I played sports, but I think if you of all people shouldn't be making conclusions when you don't have the basis of it. And if you know anything about familial tremors, you know it has nothing to do with competency and incompetency, and it is one of those situations that's traceable. That is of all human qualities, one of the least problematic of all. You are the function of, you are the focus of this.
There are
You
some
and your
conditions
actions,
in which
you
people are not
I'm sorry,
aware
sir,
that
you
they are
interrupt.
having problems.
You interrupt, and we can't both speak when this court reporter is taking down. I've really had to scold people in the past, but I shouldn't be scolding somebody like you, except I've come to know enough hearings that you want to control every hearing. You want it on your terms. And the fact of the matter is, you were indicted by a grand jury. You have had hearings here where this court allowed you to post bond, and then you violated your bond conditions. And then the statements you have made, not only at this court about alcohol abuse, God, my goodness, everybody knows differently, and then you attribute that as familial tremors caused by alcohol inducement. That's bizarre. You know it, and I know it. You just don't have the basis of connecting that a physician should have in any education that you have had up to this point on making a diagnosis of bizarre terms like you have made. But the point is when you're here, you say things that roll the eyes of everyone. You accused your neighbors of attempting to harm, deliberately trying to harm you by using microwave energy with little or no basis.
I don't know if you guys remember the neighbors. They were there one of the hearings. At least the husband was. Man, was it the husband? I don't remember. It might have been both. But yeah, let's just say they're elderly. I doubt that they're using any kind of microwaves to harm you. Uh, yeah, just I'm gonna stop it at that. But yeah, it doesn't really fit.
The rules of law will apply, as they should in all cases here. Chapter 46B of the Texas Code of Criminal Procedure deals with incompetency to stand trial. Under 46B.004, the issue of competency to stand trial was raised, and it was suggested by your attorney on your behalf. The court ordered an analysis to be made by a competent physician, doctor of psychiatrist, Dr. Ed Rapine. He was an expert under 46B.022 who examined you, filed his report under Article 46B.025, and his report states that you are incompetent to stand trial and proceed to a resolution of your legal issues, that you are mentally ill. And from testimony of the neighbors, they fear for their safety because of the actions you have taken in your bizarre response to your theory that the neighbors are conspiring to harm you with electromagnetic energy. The law places the burden of the trial court to conduct the informal inquiry that this court has done, and that resulted in the ordering of the examination on competency. Some evidence standard is met, and this to proceed to the competency issue, there is a bona fide doubt standard for determining whether there should be an inquiry that this court reasoned was valid, and that the court may make an initial determination of your competency to determine whether examination should be made not only based upon the court's own observations, but other information the court may receive in its hearings, and may make a determination on competency based not only on the court's own observations, but also with a psychiatrist's report as been submitted in this case. Thus, the issue of competency is before this court, and this court deems that the evidence supports fully that the defendant is incompetent to stand trial and is unlikely to be restored to competency in the foreseeable future, based upon the information from previous hearings, and then most importantly, the evidence submitted from Court's Exhibit Number 1, admitted without objection, Dr. Edward Pond's report, and the other statements, bizarre statements that are being expressed by this defendant. So, Dr. Bordash, the court will deem you at this time to be medically deemed incompetent. We are going to transfer you to the proper state medical facility, where treatment will be made for you, and that you will hopefully cooperate in that treatment. And our whole hope is that one day soon, hopefully, that competency will be restored to you. And this court will sign the appropriate orders to ensure that that shall be accomplished. Anything else to be added by the state?
No, Your Honor.
Added by the defense?
No.
All right, we are in recess on this. That is all. Here's this.
All right. So that is probably the last time we're going to see him in court. Maybe not, but most likely. Anyway, let's see. Yep, I knew I had one. Sparkle Poots, thank you so much. Big and holding hostages again. I mean, he likes to do that. Thank you, Sparkle Poots. I appreciate it. All right. Moving on. What do we got? What do we got next? You guys know? I don't.
In state.
Oh, I played this one. I made a video of this today. All right. I'll let it play. It's a short one. For those of you that haven't seen the video I put out today, I actually put out part 2 of this. So this happened yesterday. He was in court in person today. I forgot I threw this in my live. All right, let's go.
Of Michigan versus Johnny Buckner Jr. 2500242FY.
Oh, Jeffrey Middleton on behalf of the people. Sorry.
Good morning, Your Honor. Melanie Albirangi for Mr. Buckner, who's appearing by Zoom.
And you are Johnny Buckner Jr. on the video?
Here we go.
Yes.
You. Today is the date probable cause conference. We have a preliminary exam set for next week. I also have here a bench warrant that I've issued for arrest of Mr. Buckner. This bench warrant is pertaining to a violation of the no contact order. So I'm going to arraign Mr. Buckner on that at this time. Mr. Buckner, it is alleged that you violated an order put in place by the court on January 28 of 2025, wherein you were ordered to have no contact with Ms. Deshea Reed. You're not to be within 2,000 feet of where she lives, works, or goes to school. The only exception in here appears to be that you are allowed to pass within the zone briefly on your way to and from work. It is alleged that on or about January 30, 2025, that you violated the no contact order via telephone calls and text messages. If that is true, the bond you are out on could be revoked. You could be in contempt of court, for which you could be sentenced up to 93 days in jail and or $7,500 in fines consecutive to that which you already face. You should understand that you have the right to have an attorney in this matter, and Ms. Wanji is already representing you in this case. You have the right to a trial by a judge, not by a jury, but it would have to be proven beyond a reasonable doubt that you did in fact violate a court order. Ms. Wanji, are you asking that this be set for a hearing?
Yes, Your Honor, thank you.
All right. Are we going to leave the exam as scheduled for the 13th?
Yes, Your Honor.
Okay, so we'll set this for the same time. Feb 13, 8:30. Ms. Wanji, as for bond on this,
Yeah, I said that a couple minutes ago that I forgot that this was in my live. Now this video that I'm playing tonight, there's 3 clips. I forgot this was here. I thought there was only 2. The next one's a Judge Middleton hearing. This video was supposed to be last night's live stream. Team Skeptic came on my live panel last night, so I swapped the videos and did the video that we covered instead of this one. I was already set up for my live when he said he was available, so that's why I just used this video tonight instead. But yeah, this guy had his second appearance today, and yeah, if you want to, I'll explain that here in a second.
bench warrant here.
All right.
I will ask the court to set a PR bond. This case, I think that my client will be able to show that he did not violate the bond conditions, and I think it will also be detrimental for him to be in jail when he has to prepare for this matter. The preliminary exam is next week, and he also has a job. He already lost one job because he was in jail last time. Otherwise, there is nothing in the court file saying that he has already violated the other condition besides these allegations that he violated the condition of his bond, that he has a tether on. So with the tether, it's easy to know where he was at the time that is alleged that he may have violated the condition of the.
But the violations aren't just the allegation that he went within the zone. The violations are text messages, which include, you're trying to keep me from my son. I'm going to call CPS and have them take him from you. You have until tomorrow morning to let me see my son. So all of those messages would be a potential violation of the no contact order if he did in fact send them. At this time, bond will be set at a PR bond, but if these violations are substantiated, there is a good probability Mr. Buckner is facing jail. Bond is set at $5,000 personal recognizance with all conditions at this time remaining in place, and we will have our hearing next week.
Okay, thank you, Your Honor.
As for the people, anything else that we need to address?
No, Your Honor.
Okay, Mr. Buckner, remember that you are in fact on bond. You need to be reporting to pretrial services. Have you reached out to them?
No, my phone broke. I can barely do anything. I'm using somebody else's computer.
Person, if you don't call them, you know what? I just arranged you on a bench warrant. You're telling me that you're not compliant with bond, and your attitude is that you don't intend to comply. Instead of doing what most defendants do at probable cause conference, which is say, I'll call them today. I'll go there today. I want to be compliant with my bond. You just say, I can't do anything.
I'm letting you know my phone is broke. I can't call nobody.
Then you
Yeah,
need to
I
go
can
there.
barely
Then you need
go
to go
where
there.
with what ride?
Your
What
Honor, I
ride?
will
What
talk.
car do I have?
Mr.
All my
Buckner,
cars are sitting
Mr.
at the house.
Buckner,
Okay, I'm sorry. Mr. Buckner has an in-person hearing next week. His attitude is inappropriate. So I guess I'm going to revise and I'm just gonna let the bench warrant stand and have him.
Oh, ouch. Yeah. Yeah, this is how I talk. I'm not giving you any attitude. No, that's attitude. You need to fix that. That's how you talk to people. And yeah, well, I knew you were joking. And also, yeah, absolutely lazy. I could have put a video out. I could have made the video tonight with things that happened today. But one, Friday generally sucks. Friday court's really slow. A lot of landlord tenant stuff. There was one really good landlord tenant case in DeSanto's court, which I'm going to do a video on. But it ended up being, I think the hearing was 2 hours long. It was long, so I was like, it's gonna take some editing, so that's not happening tonight. Anyways, but yeah, absolutely lazy that I just recycled last night's to tonight. But so I agree with you.
Turn himself in on the bench warrant.
I'm not even talking rude. This is how I talk. I'm
Your
letting
Honor,
you know my phone is broken. I told my prosecutor
Mr.
this
Buckner,
yesterday.
please, Your Honor, I will have Mr. Buckner come to our office today. I will be there. He's going to call Quick Health Services using our phone.
Well, you'll have to have him come by the court also to get arraigned on his bench warrant, because I'm gonna keep the bench warrant in place. His response today gives me no confidence in his following court orders. All right, that will conclude this hearing. We'll continue it when I see Mr. Buckner in person.
Thank you, Your Honor.
Thank you. You can click leave there, Mr. Buckner, and get out of the Zoom. All right. Wait.
All right. So that happened yesterday. He did show up today, which means he turned himself in. He was in handcuffs, and he just was polite and as nice as he could possibly be. Very straightforward with Judge Buchanan. So she let him out. That's what happened. If you want to go watch the video, I released that one. I think that was my afternoon release. So that would have been, I don't know, between 2 and 3 o'clock, I think, this afternoon. It's my latest video, not live stream, my latest video. Anyways, let's move on. Next one, we have Judge Middleton. Judge Ponytail, that some of you like to say in chat. So let's go.
Good morning, sir.
Good morning.
Well, this is Judge Middleton. I'm here with Jeanette Jackson from the Public Defender's Office. When I came and logged in this morning, I saw that you'd been arrested last night. There have been 2 warrants out for your arrest for some time. They set this matter for 1 o'clock, but the public defender was here and no need to wait till 1 o'clock. Let's talk about both of these. First case is 24110 SM. In that case, it's alleged that on or about October 18th of 2023, way back when, you stole some property from the Speedway gas station.
Carrie, that is awesome. Thank you so much. I'm going to jump over and pin that if you guys want to watch part 2. Please wait till after the stream, though. But yeah, thank you, Carrie.
Worth $115. I believe it was cigarettes, some other stuff. And you had a previous offense, so they charge it as domestic violence, a retail fraud 2nd degree. That's a misdemeanor, punishable by up to a year in jail and a fine of $1,000. Alleged that you took some cigarettes and cell phone charging cords. Apparently it's on video. You had got arrested. This warrant issued in January of 24. You got arrested in September of 24. You got arraigned at the jail and you posted bond either that day or the next day. That's when our problem started. You failed to appear for your arraignment. I did a show cause. You failed to appear for that. I moved to forfeit your bond. You called in, said you'd been sick. They rescheduled the arraignment.
Yeah, it's kind of annoying. I didn't notice that the first time I heard this. But it's annoying. I don't like it. I probably wouldn't have played this case if I would have paid more attention to it or to that noise, not the case. The case is actually interesting and good, but that noise is annoying.
For November 20th, you didn't show up for that. We had a 2-hour delay, so I reset it again. Then you got arrested last night. The other case is a malicious destruction of property.
2023.
That retail fraud was 2023. This is, August of 23. So all this stuff is old.
I was just, Judge, I just
Well,
did
just a
6
minute.
months.
Let me tell you what this one is. Then we'll
I just
discuss
did
it.
6 months in here and you guys didn't even charge me or anything while I was here. It's been 2 years. I got stage 3 cancer. I'm doing chemotherapy. You guys need to get the shit together, man.
Slow down. It's not you guys, it's the prosecuting attorney's office.
Well, it's been
I didn't have anything to do with it.
I just did 6 months in here. You guys should have charged me then.
Well, they charged you in
January
January of 2000. January of 2024. You got arrested in September of 24. You haven't been in jail between September of 24 and now, have you?
Let me see, 2024, I'm not sure. I just did 6 months in here. I spent Thanksgiving, Christmas. I got released in February. I'm not really sure because.
All right, well, you got released, you did this Thanksgiving of 24?
No, last Thanksgiving.
Yeah,
last Thanksgiving,
you're right.
and Christmas. I did last Thanksgiving,
Well,
Christmas.
all right,
I got
so
out in February.
they didn't charge this until January of 24, after you got out. So the problem is you got arrested in September and then you failed to appear. You called in a couple times.
Can I please speak, Judge? I have not been able to do anything. I've been doing R-CHOP chemotherapy, 6-hour sessions, every 3 weeks. Like, I can't do nothing. I can barely even talk right now. And you guys got me in here screaming, look, you're either gonna charge me and let me do my time or let me go, dude. I have chemo coming up. I'm on the verge of dying. Like, this shit's not that important. This shit's not worth my life, man. A couple packs of cigarettes is not worth my life.
I don't disagree with that. But stop playing poor me. It's your own damn fault. Stop. You got arrested. You bonded out and then you never came back. I said it like 3 times. I know you have cancer and I know you're going through chemo. So I went out of my way to not arrest you, but I set 3 hearings and you didn't show up for any of them. So poor me. All right. So how did you get arrested last night?
I was at home. I have a psychotic sister. Her name's Melissa Watkins. She likes to call the police on everybody. She likes to start shit with everybody, call the police on everybody. She's a complete piece of shit. She just stabbed like some girl a couple months back.
All right, well,
like,
stop.
I live with a psycho that likes to call the police all the time. Sorry. She called the police on me. I have warrants. I went to jail.
Oh, so you live with someone that's not stable, which, that might be the pot calling the kettle black. But anyways, he's living with her and they don't like each other. She knows he has a warrant. Why are you putting that power in her hands? Like that just seems like it's obvious. The first fight they get into, I'm calling the cops, you're going to jail. Come on, man.
Stop swearing, by the way, or I'll just hang up and we'll do this tomorrow. Why did she call the police? Because she knew you had the warrants out?
No, we have been arguing because me and her do not get along. I went to my mother's house to do chemotherapy and I was gonna do the 6 sessions there, get better and move out. Well, she can't get her stuff together because she don't know how to take care of her daughter. She don't know how to do nothing. So she keeps moving back in with my mom. I keep calling her out on her bull crap. And she don't like it, so she don't want me there. So she knew I had warrants, so she called the police on me. And I got arrested by the state cops.
State police are pretty good at serving their warrants. All right, where are you gonna go if I let you out of jail?
I am gonna go to the homeless shelter. I already have a spot set up there. I was on my way there yesterday when I got arrested. I was on my way there. I was gonna go there, get a spot, and have them help me out with my last couple chemos. That way, I'm not there with her because I can't be around my sister, man. I was planning on leaving earlier that day, but I wasn't feeling good, so I wanted to get some sleep. I got a little bit of sleep, and then I started feeling better, and I decided to leave, but we had an argument before I left. She called the police, and I was on the highway walking to the homeless shelter when the police stopped me and got me.
Well, I've had lots of drama with the Watkins down in White Pigeon. Lots of family. I knew your dad, and you and your brothers and sisters have been fighting with each other for several years.
Can I say something, Your Honor? It's mostly my sister. She causes all the problems. She's the most violent one out of all of us. And every time the cops come, she plays poor me, and they arrest us and they bring us to jail. She has put all three of her brothers in jail on a spoof, man. She's put me in jail. She's put my brother Josh in jail and her youngest brother in jail. All he's ever done is help her.
Well, I've dealt with both of those guys.
You guys need to do something about her, man. You guys need to do something about her, man.
All right, well, I'm only the judge. I'm trying to figure out what to do with you. Now, so you were living at the trailer park in White Pigeon?
Yeah, I was staying with my mother, yeah. I've been there the whole time, Your Honor. I have not left. I've been really sick. I haven't been able to do anything. I've been really sick. Like, I've been trying to just get better. You know what I mean?
Well, all right, you've had from September till now to just walk in the front door.
I know.
And you knew it. You let your sister. All right, if you don't stop interrupting me, I'm gonna hang up on you. I'm gonna do this tomorrow. You can sit for a while and think about it. So let me talk.
I'm sorry.
The last address we had for you is Oak Park Road, but your mother lives at the Colonial Crest or whatever that one's called. So you knew you had these warrants. You even called a couple times, but you never bothered to come in to deal with them. So you let your sister have the authority to pull a string on you and get these warrants served. That's your own damn fault.
Yes, it is.
I am concerned about where are you doing your chemo?
I do my chemo at Bronson Oncology, 804 John Street.
How do you get there?
I get there through my medical rides through United Healthcare. I set them up 3 days in advance. They pick me up.
Good. Do you have any source of income?
I do not, Your Honor.
Have you applied for Social Security disability?
No, I haven't.
Why not?
I didn't think I'd be eligible.
Well, they deny everybody the first time, but I'm guessing that your current medical condition would make you eligible.
I did not know that.
All right, well, a couple things. The sheriff doesn't want you in jail because of your compromised immune system and your chemotherapy that you're under. I didn't even finish the other case. The other was a malicious destruction of property. You got your chain yanked by Judge Pattison because you kept having contact with Mandy Cox.
Yeah.
And that's why you were in jail for 6 months. I don't know why the prosecutor took from August of 23 to January of 24 to authorize this, but that's why you were in jail, because And it's an MDOP of Mandy Cox's property, and you went to jail for having unauthorized contact with Mandy Cox. You posted a bond way last February, and then promptly proceeded to never appear for anything. No, you didn't get arrested until September. All right. If you're going to the homeless shelter, you're gonna come here anyway. I'm gonna order 1 day jail, credit 1 day for failing to appear in each case.
I will be here for court this time. I will be in Centerville. There's no reason why I cannot show up for court if I'm living in Centerville.
Yes.
I want to get it taken care of too, Judge. I really do. I don't want to have this hanging over my head anymore.
Well,
I've been
it's
in so
not,
much
none of it's
trouble.
the crime of the century. You allegedly stole some cigarettes and some charge cords, and then you allegedly slashed Mandy Cox's tires, neither of which were real good decisions. On the MDOP, one day credit, 1 day. I'm going to show a plea of not guilty on each case. If it weren't for your medical disabilities, I'd leave you in jail. But the reasons I stated, the sheriff doesn't want you in there. So I'm going to appoint an attorney, set attorney pretrial for March 7th at 8:30, both cases. I'm not instituting any, you've already got conditions regarding Mandy Cox, but there's nothing then here would prohibit you from going back to your mother's house. But that's up to you. If you go to the homeless shelter, you need to be here. Now, when you get out of jail here today, you come up here to the courthouse and we'll give you this paperwork with your attorney. If you need a bus pass, I'll give you a bus pass. But if you're just gonna go to Keystone, you can walk from there. So you come up here to the courthouse. I'm gonna reinstate the original bonds. That you
I just need
posted.
to go back. I'm sorry. I was just gonna say I need to go back to my mom's house to get all my stuff. That's all I gotta do.
Well, that's up to you. If you need a bus pass, I'll give you one when you come to the courthouse.
Okay, that would be great.
I have a
Thank
lot of generous people that provide them. All right, so here's the deal. I show you pled not guilty on both cases. I reset this for a pretrial with an attorney for March 7th. You need to show up. Ignoring the hearings has not been a very successful strategy. That's why you're in jail right now. I would just leave you there until March 7th or February 21st, but you've got significant medical problems. And I was aware of that, which is why I was going out of my way to not arrest you, but you were rolling in a different direction. So you come up here to the courthouse, we'll give you your attorney name and number, and we'll give you the information regarding your appointment. It'll be live here at the courthouse on March 7th. All right, Mr. Dodd.
Thank you. I apologize for yelling. I'm sorry.
Well, you're quite invested in your own situation. All right.
All right, guys. That is it. That is it for the evening. Thank you so much for hanging out with me. And again, thank you for your patience at 8:30. I really wish that that just figures itself out. Yeah, I don't want to get into that, but you guys are awesome. Thank you guys so much for the membership milestones and the super chats. We are set to raid Lone Wolf, so we're gonna go over there. Make sure you tell him I sent you, and yeah, that's it. I will. Oh yeah, I guess I should say this. Um, Tomorrow night's date night, so no stream. I am most likely taking Sunday night off since it's the Super Bowl. I don't know yet. I don't know that for a fact. So I would say assume I'm not going to be streaming Sunday night. Pretty much if the game is boring, then I'm going to stream. And yeah, I don't really care for either team, but it's the Super Bowl, so I feel like I have to watch it since I'm a football fan. But if the game's boring, I might just decide to go live. I don't know yet. But as of right now, I'm probably not going to stream. So I won't see you guys until Monday for Members Monday, which is actually, I think Monday is the next day that we get to see Eric Martin in court. I'll have to double check that, but I know it's next week sometime. And that in my head, I think it's Monday. What else? I think that's it. I think that's it. You guys are awesome. Yeah, yeah, Cheshire Cat. Cheshire Cat. Thank you so much for the super chat and good to see you. All right, I'm gonna let it go. I'm gonna let it go. I'm gonna let it play out. You guys have a great night. Have a great weekend. Don't do anything dumb. I will cover you if I see you in court. That's a promise. So just be safe. Don't do anything dumb. All right. Until next time. Bye.
All right, we're gonna appoint Jeanette Jackson as his attorney. She'll fix all this.
Yeah. It'll be with Slavin. I have to double check that it's Monday. You know what? I can just do that real quick. Since you asked, I will double check. See. So the Monday is the 10th. What do we have? Yeah, it's the 10th. The 10th at 1 p.m. So it'll be in the afternoon with Judge Slavin. All right, now I'm out. Peace.